friends, this is Jonathan Lipson with The Real Deal on Contracts. Today we're going to talk about warranties. If you are in my class, this corresponds to Unit 27. We'll talk about three things. Number one, how do we know if there is a warranty in a contract? Number two, how warranties can be disclaimed in contracts. And number three, assuming there are warranties that have not been disclaimed, how, if at all, can a seller limit remedies for the breach of a warranty? Number one, is there a warranty, and if so, what is it? The legal system, as a general matter, recognizes two different categories of warranties. Number one, express. Number two, imply. Talk about each of them in turn. An express warranty at common law is any material, factual statement in a contract on which a party has relied. We don't spend a lot of time on common law approaches to warranty because, for the most part, the UCC has a very sort of rich and, I think, useful set of rules that we can follow. But remember, warranties can arise under common law contracts just as they can under UCC contracts. An express warranty under the UCC is defined in 2.3.13 as any affirmation of fact that becomes part of the basis of the bargain. Right? So what that means is that things like descriptions of the goods sold, samples of the goods sold, language that factually describes what's happening is going to be a warranty that is express under the contract. We distinguish express warranties from affirmations of value, statements that are opinions, and so on and so forth. A little bit like the distinction we saw between fact and opinion in Volks and in Abdi. Not necessarily concerned about fraud here, but the same basic idea is that we care about facts. Those can make warranties. We don't worry so much about opinions. The other kind of warranty is an implied warranty. And this is a warranty that literally the state, through the Uniform Commercial Code, is imposing on certain kinds of contracts. There are two implied warranties that we care most about: the warranty of merchantability and the warranty of fitness for a particular purpose. The warranty of merchantability under 2.3.14 is essentially a warranty made by any merchant seller that is selling sort of goods of the kind that the seller ordinarily sells. So what you need to know is, number one, is the seller a merchant, defined in 2.104? And number two, is that merchant selling goods of the kind that they ordinarily sell? If they do, then you need to figure out what they're selling is merchantable. It's a funny word, but under 2.3.14, that means that the goods sold must pass without objection in the trade. They must be of fair average quality, fit for their ordinary purpose, conform to any promises on a container or label, and so on. Warranty of merchantability is basically setting a baseline of quality that any merchant is deemed to make as a matter of law, unless, of course, they disclaim it, which we'll come to in a moment. The other implied warranty, fitness for a particular purpose. 2.3.15 says that if the seller knows that the buyer is relying on the seller's skill or judgment in selecting or furnishing suitable goods, then the seller is deemed, as a matter of law, to make a warranty of fitness for the buyer's particular purposes. Hard questions here involve things like, well, how do we assess buyer's reliance? Was the buyer's reliance reasonable? How much skill and judgment are we expecting of the seller in order to say that they are deemed to make this warranty of fitness for a particular purpose? Sometimes I'll abbreviate that FPP. A third problem that arises in determining whether there is a warranty is what we do about conflicting warranties. UCC 2.3.17 has some rules on this. We try to construe them, multiple warranties, consistently and cumulatively, which simply means we want to read the contract in a way that makes sense of all of the words in it and does so in a consistent way. But if it's unreasonable to do that, if we have warranties that just conflict with one another, in particular, then we have to determine what the intentions of the parties were with respect to warranties to decide which one is dominant. That's the term we use in the UCC. 2317 has a hierarchy of kinds of warranties, which ones have priority over other ones, in an effort to determine sort of what rules we use to decide the parties' intentions. As a general proposition, I think the more specific and explicit the warranties, the more likely they will be to dominate over more general or vague warranties. In this context, by the way, sometimes buyers will want to introduce what is known as parole evidence, extrinsic evidence. We've talked about that briefly already. We'll come back to it in Unit 28. So, part 1, do we know, whether there is a warranty, and if so, what is it, right? Express, implied. Part 2, if there are warranties, have they been disclaimed or limited? This takes us to UCC 2316, which has rules about this, and it really depends on what kind of warranties we're talking about. Let's first discuss disclaimers or limitations of express warranties. UCC 2316 basically says that the negation or limitation of an express warranty will be inoperative if it's unreasonable. And what I think that really means is that any contract for the sale of goods is going to involve some goods, and that means that the contract is going to have a description of those goods. That description itself is going to be a warranty, probably cannot be disclaimed. So, for example, classic disclaimer language in a contract might be something like, we're selling as is with all faults, we're making no representations or warranties about anything. Does that disclaim all express warranties? Probably not. It's probably still making a representation that the thing that is being sold is the thing, right? So if it's selling a car, but it's selling it as is, it's still a contract that's making an express warranty that the car is a car and not, for example, a goat or something else. To disclaim implied warranties is slightly more complicated. For the warranty of merchantability, you can disclaim it if you are a merchant seller, but you have to do two things. You must mention merchantability, which sounds like a silly thing to do, but that's what you have to do. And if you have a written contract, then the disclaimer of merchantability must be conspicuous, which is defined in 1201.10 in a particular way that you might want to take a look at. To disclaim the warranty of implied warranty of fitness for a particular purpose, the disclaimer must always be written, and it too must be conspicuous. Can a merchant seller disclaim all warranties? With respect to express warranties, I think the answer is probably not. I think the mere description of goods itself constitutes an express warranty. As to implied warranties, absolutely yes. You can disclaim all implied warranties. Fitness for a particular purpose, merchantability, and any other implied warranties that might arise can be disclaimed under 2316. 2316 actually gives you some specific language on how you do this. As is, with all faults, will be effective if conspicuous. So too will the opportunity to examine. So if the buyer has had a chance to examine goods or has had the opportunity and refused, then that might function as a disclaimer, even if it's not necessarily written down. One final point about disclaimers. There's a federal law known as Magnuson-Moss that limits merchant sellers' ability to completely disclaim implied warranties in sales to consumers. So we've talked already about how the dynamics of business-to-consumer transactions, B2C transactions, might be different in some respects than business to business. Magnuson-Moss is evidence that they are regulated in a sort of special way. Merchant sellers cannot disclaim all warranties, implied warranties under Mag-Moss, but they may make limited warranties, and that's typically what you'll find. So that's disclaimers. Can you disclaim warranties? Yes, to a significant extent, but you have to sort of follow the rules in the UCC to do so. Number 3, and finally, if there are warranties that have not been disclaimed or limited and have been breached, can the seller still limit its liability for the breach of the warranties? And the answer is yes. They can do so either through the use of a liquidated damages clause, which we've talked about already, 2718, enforceable if reasonable and not a penalty, Or, and this is what we need to talk about now, through the use of a remedy specification clause or limitation clause in 2719, permitted by 2719. Under 2719, the classic remedy limitation is promised by the seller to repair or replace goods that might be defective. There's nothing wrong with that. In fact, the UCC sort of encourages it. What that means is that the seller might say, well, the sole and exclusive remedy that you have for breach of warranty is the repair or replacement of whatever we sold you. Meaning, in theory, that you can't get other remedies like damages. Remedy limitations may also say no consequential damages, no incidental damages, and those too are generally permitted under 2719. However, there is a limit. If a remedy limitation, quote, fails of its essential purpose under 2719, 2 and 3, or is unconscionable, then the limitation is ineffective. And in that event, the other remedies provided in the UCC, for example, the expectation measure in 2714, and perhaps consequentials, will be available to the aggrieved buyer. So although we can limit remedies contractually, not a problem, the limitation cannot be so severe as to fail of its essential purpose. We'll talk about what that means, because if it does, then the seller hasn't, in fact, effectively limited its obligation to remedy the breach of warranty. Instead, they are now exposed to all of the UCC's warranties. That's the real deal on warranties. We'll talk more about this in class.